Hello, everyone. My name is Timothy Innes. I am the Reference and Academic Outreach Librarian at the John F. Schaefer Law Library, Michigan State University College of Law, and Professor of American Legal History at Western Michigan University, Cooley Law School. This is part two of a YouTube presentation concerning the legacy of Chief Justice of the United States Supreme Court John Marshall and his influence on constitutional development. These videos are presented in conjunction with the American Legal History podcast, which traces the history of American law from its ancient roots to the present day. The American Legal History podcast is available on Apple Podcast platforms. The information in this video is derived from episode 23 of the podcast. I want to begin with a quote from legal historian G. Edward White that underscores Marshall's influence, followed with an explanation of how Marshaall was able to shepherd so many important cases to the Supreme Court. First, the quote. By the death of John Marshall in 1835, the court had become a major factor in American life. It had demonstrated that it was capable of addressing every important issue of early 19th century politics, whether that issue was slavery, the status of American Indian tribes, or the state taxation of federal institutions, or the relationship between states and private colleges and universities, or state regulation of steamships and turnpikes, or the extent of the federal court's admiralty jurisdiction. The court had found that a provision of the Constitution affected the issue and offered an interpretation of that provision. So how did John Marshall get the most important issues of the day presented to the Supreme Court? Really in four ways. The first was a natural phenomenon that would have happened without Marshall. There was and is two primary reasons that litigants bring their disputes to the federal courts. Either it involves a federal question or the plaintiff and defendant are residents of different states. The explosive growth in population and commerce between the states stimulated that number in both categories, in particular diversity cases. The second was the so-called certificate of division cases. These would prove to be the principal method of shepherding cases from the lower federal courts to the Supreme Court. The Judiciary Act of 1802, which replaced the Judiciary Act of 1801, created a new arrangement for Supreme Court circuit duties. Justices riding circuit would preside with one district court judge in the federal circuit court. If the two disagreed, a certificate of division would send the case to the Supreme Court. It did not take long for judges and justices to come to a gentleman's agreement to agree to disagree if they spotted an important case. The third factor involved the manner of rendering Supreme Court decisions. Prior to Marshall, the Supreme Court followed the English practice of issuing decisions known as seriatim opinions. Each justice wrote a separate opinion, which were published in reversed order of seniority, with the Chief Justice always last. This was followed by a brief paragraph with the heading, "By the Court," disposing of the precise questions being litigated. Marshall eliminated separate opinions. Even dissenting opinions became rare, occurring only 10% of the time over his tenure. The last factor, which would prove surprisingly important, were the living arrangements. The Supreme Court term was short. From 1803 to 1827, it began on the second Monday in February. After 1827, it began on the second Monday in January, but in either case, never lasted beyond the third week in March. During the term, the justices lived together in a boarding house and developed a collegial decision-making process. Oral arguments began at 11 a.m. and ended at 4. Back at the boarding house, the justices met and often decided on the disposition of the case immediately, that is, whether to reverse, remand, vacate, or overrule. After that, more often than not, Marshall himself would be assigned to write the opinion. He wrote an astonishing 547 opinions during his 34 years as Chief Justice. During the same period, the other justices combined wrote 574 opinions. How can we explain this unparalleled proficiency? There are several reasons. Marshall's pleasant, jovial temperament, energy, and willingness to compromise, even on issues he was passionate about. Over the course of his presidency, Jefferson attempted to nominate justices who would effectively thwart Marshall's judicial vision. However, his three appointments, Justices William Johnson, Henry Livingston, and Thomas Todd, all fell under Justice's so-called spell. Another factor in the court's ability to expand its docket, decide cases quickly, and with great deal of unanimity was that between 1811 and 1823, its personnel remained constant with zero turnover. These were the years, as we will see, in which some of the most important opinions in American history were issued. One more conversion story is that of Joseph Story. Story joined the court in 1811 at the tender age of 32, nominated by none other than Marshall's old nemesis, James Madison. He was a Jeffersonian Republican, but also possessed a jovial and agreeable temperament. Marshaall, who was already 56, took an instant liking to the young man, and they became the closest of friends and colleagues. Justice Story is the second most significant figure in early American judicial constitutional history, and only the Chief Justice himself wrote more opinions than Story. He served with distinction on the court for 33 years. In addition, he wrote some of the most important legal treatises of the time and helped to transform legal education as the Dane Professor of Law at Harvard. In 1827, Justice Story wrote an article in the North American Review on the life and service of Chief Justice Marshaall. Keep in mind the following passage may have the tone of a eulogy, but was written some 8 years before Marshall's passing. Quoting now. Interesting as it is to contemplate such a man in his public character and official functions, there are those who dwell with far more delight upon his private and domestic qualities, to be amiable, as well as great, to be kind, gentle, simple, modest, and social, and at the same time to possess the rarest endowments of mind and warmest affections, is a union of qualities which the fancy may fondly portray, but the sober realities of life rarely establish. Close quote. Okay, with that foundation laid, let's move on and examine what are considered some of the foundational cases in Supreme Court history. You may recall, if you are a listener to my podcast, in the first of the episodes about the creation of the U.S. Constitution, I said that not only is our written Constitution the oldest in continuous use, but it's also the shortest. And this has come to be seen as one of its virtues, because it presented a framework of government, like the framework of a house. It would be left to later generations to complete it and construct it. This is why the Marshaall Court is held in such high esteem, because in a relatively short amount of time, they established some of the basic constitutional principles that are accepted as the law of the land today. Most of the cases discussed here were decided between 1810 and 1823, the most productive period in Supreme Court history. During this time, Marshaall and his fellow justices, in particular Joseph Story, were at the height of their intellectual and persuasive powers. Between 1810 and 1823, the Marshaall Court decided Fletcher versus Peck, United States versus Hudson and Goodwin, Martin versus Hunter's Lessee, United States versus Coolidge, Sturgis versus Corningwell, McCulloch versus Maryland, Trustees of Dartmouth College versus Woodward, Cohen versus Virginia, Green versus Biddle, and Gibbons versus Ogden, just to name a few. Let's begin with an 1810 case that would establish both nationalistic and anti-populist principles, Fletcher versus Peck. The case has its roots in the so-called Yazoo fraud of 1795. In that year, the Georgia legislature sold 35 million acres near the Yazoo River to 4 land companies for a paltry $500,000, less than 1.5 cents an acre. Many members of the 1795 legislature held stock in the companies, as did other state or federal officials, or were just outright bribed. The resulting outrage when the truth came out led to the election of a new legislature in 1896, who rescinded the sales, declaring the authorizing act unconstitutional, and voided the transactions made under it. It then took the extraordinary step of burning all the records of purchase, but did not bother to return the $500,000. Fletcher versus Peck was a collusive suit brought years later to test the constitutionality of the 1796 Georgia Repeal Act. Just for clarity, a collusive suit is a lawsuit where the parties are not actually in disagreement, but are cooperating to steer the court towards some agreed upon conclusion. A very important point here. Although Marbury versus Madison clearly established judicial review, the power to declare an act of the legislature unconstitutional, it did not establish it as an exclusive power of the judicial branch. In 1792, the Virginia Assembly had declared one of its laws unconstitutional under the Virginia Constitution, and President Jefferson also claimed the executive had power of review. This is known as the departmental theory of review, that each branch has a power to review within its own sphere. In addition, Georgia's Repeal Act represented not only an assertion of the legislature's right to review the constitutionality of legislation, but also a challenge to the sanctity of contract. As such, it was a direct assault on the Federalist constitutionalism. Marshaall's opinion would address both these issues. First, legislative exercise of constitutional review, he declared, usurped judicial power, and as such, it violated the basic principles of separation of powers. Second, the Repeal Act was a clear violation of property rights, one of the bedrock principles of Marshaall's constitutionalism, as well as an affront to the federal Constitution's Contracts Clause. And this is what the case is primarily remembered for: the government cannot interfere with vested property rights. This was the exact reason the Contracts Clause was put in the Constitution in the first place, to prohibit states from passing laws that would interfere with private contracts. As it clearly states in Article 1, Section 10 of the Constitution, quote, "No state can pass any law impairing the obligation of contracts." Quote. On the other hand, the Republicans are sometimes referred to as the Democratic Republicans, or sometimes the Jeffersonian Republicans, believed that Georgia's action was a legitimate exercise of popular sovereignty and states' rights, and thought that an act of popular constitutional review was clearly superior to any act of mere judicial review. For the Federalists, popular sovereignty could never be taken that far. The people were not competent, through their elected representatives, of changing the terms of the Constitution except by Article 5. In short, courts, not people, interpreted and applied the law. This was not judicial supremacy, but rather an argument for leaving adjudicatory functions to adjudicatory institutions. In his opinion, Marshaall declared the 1796 repeal law was unconstitutional because the sales made under the 1795 law were, quote, "in its nature a contract, and absolute rights had been vested under that contract," close quote. This case established that the rule of law required that private rights be governed not by the people's will, but by, quoting here again, certain great principles of justice, such as the rule that good faith purchasers should never be molested in their title. In the end, the case did not settle the continuing debate about the nature of the Constitution. It did show the major disagreements about that nature, however. In United States versus Hudson and Goodwin in 1812, in United States versus Coolidge in 1816, the Supreme Court ruled there could be no federal common law of crime, and the prosecution in federal courts had to be based on federal statutes. These seminal cases will be examined in much greater detail in a series of later episodes on the history of criminal law in the United States. After Fletcher, Marshaall would continue to build his version of Federalist constitutionalism in cases such as Martin versus Hunter's Lessee, 1816, which is surprising in that Marshaall himself was one of the interesting parties. The case involved the sale of some 160,000 acres of Virginia land to Marshaall and members of his family, which had been confiscated from the Loyalists during the Revolution. Now those titles were in question. The result of the 1783 peace treaty with Great Britain. The twists and turns of the case would take too long to unravel. Suffice it to say, the case clearly established the supremacy of federal treaties over state law, and more importantly, the power of the United States Supreme Court to review and overturn, if need be, cases from state Supreme Courts. Okay, let's talk about a truly foundational case, McCulloch versus Maryland, 1819. This was a case that would ensure that the national government had the power to govern effectively. It lifted the doctrine of implied powers to a new constitutional plane, resolving in the process controversy that had raged in the early days of the Republic between those that favored a strict and those that favored a broad construction of the Constitution's necessary and proper clause. This appears at the end of Article 1, Section 8, quoting, "The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by the Constitution in the government of the United States, or any other department or officer thereof." Close quote. The strict view urged by Jefferson and the Republicans emphasized the word necessary in the clause, arguing that it gave the federal government only those powers indispensable for the exercise of its specifically enumerated powers. The broader view advocated by Hamilton and the Federalists argued that to take the word necessary in its rigorous sense would be to deprive the clause of any real practical effect. In Hamilton's words, quote, "It is essential to the being of the national government that so erroneous a conception of the meaning of the word necessary should be exploded." Close quote. In McCulloch, Marshaall adapted the broad Hamiltonian view. Though the constitutional authority of Congress to establish a national bank and the rights of states to tax them, the issue in the case, was not among the enumerated powers in the Constitution, that did not matter. If the establishment of a national bank would aid the federal government in the exercise of its granted powers, the authority to set up a national bank would be implied. The constitutional clause embraces, quote, "all means which are appropriate to carry out the legitimate ends of the Constitution unless forbidden by the letter and spirit of the Constitution." In McCulloch, the Marshaall Court interpreted the basic doctrine in an expansive way. In the opinion, Marshaall famously declared, "We must never forget that it is a constitution we're expounding, intended to endure for ages to come, and consequently to be adapted to the various crises of human affairs." Close quote. As construed by the court ever since, the necessary and proper clause is the font and origin of federal authority. Practically every power of the national government has been expanded to some degree by the clause. By refusing to bind the nation into the narrow literal confines of its granted power, the Marshaall Court enabled it to grow and meet governmental problems the framers could never have foreseen. The other important issue in the case involved the power to tax. Did the state of Maryland have the authority to tax a federal entity, in this case, the Bank of the United States? The court emphatically said no. The power to tax is the power to destroy, Marshaall famously said. A very interesting story concerning the Maryland's motivation for taxing the Bank of the United States is seldom mentioned. In 1890, the United States went through the first of its economic downturns, known in those days as panics. Many blamed the Bank of the United States, which had just been rechartered by President Monroe in 1816. In truth, there was more than a little merit in this. This was especially true of the Bank of the United States in Maryland, where not only was it mismanaged in the panic, but officers of the bank had embezzled some $1.5 million, about $25 million in today's dollars. This was the prime motivation for Maryland legislature to levy taxes on the bank. Okay, now this same expansive approach to federal authority can be seen in Marshal's opinion on the most important substantive power granted to Congress, the power to regulate commerce. Marshal's overriding concern was to interpret the Constitution to make effective national government possibly led him to describe the federal commerce power in a way that has never been exceeded. He did this in a case that every first-year law student would be familiar with, Gibbons versus Ogden, 1824. In it, he describes the commerce as all commercial intercourse, a concept comprehensive enough to include within its scope all business dealings. An equally broad view is taken on the extent of the federal power to regulate. Marshaall posed this question in his opinion. What is this power? Is the power to regulate. That is, to prescribe the rule by which commerce is governed. This power, like all others vested in Congress, is complete in itself. may be exercised to its utmost extent and acknowledges no limitations other than those that are prescribed in the Constitution. From his opinion, the Commerce Clause in the Constitution became the most important power the government could exercise, especially in times of peace. Upholding and establishing the power of the national government was only the first part of Marshall's legacy. The second was to uphold the federal supremacy over state encroachment. The Supremacy Clause of Article 6 is the very foundation of the federal system and was given full effect by the Marshaall Court. Under these rulings, all state acts are subordinate to the valid exercise of federal authority, whether expressed in the Constitution or a congressional enactment or a decision of the Supreme Court. Establishing the scope of corporate charter powers was another crucial function of the antebellum courts. Whether state judges generally held that corporate charters could be narrowly construed, the federal courts embraced a more expansive doctrine in the landmark case of Dartmouth College versus Woodward, 1819. The case involved the issue of whether the New Hampshire legislature could alter the terms of the charter originally granted to the college by King George III back in 1769. The college claimed that the Contracts Clause of the federal Constitution prohibited the legislature from impairing the obligations of the charter. The case was widely perceived as having profound implications to the extent of which the states could interfere with contracts in private business. Marshall's opinion held that the corporate charter granted by the legislature, or in this case the king, was a contract protected under the terms of the Constitution's Contracts Clause. Marshaall, in a forceful and emphatic opinion, said, quote, "This is plainly a contract which the donors, the trustees, and the Crown, to whose rights and obligations New Hampshire succeeds, were the original parties. It is a contract made on valuable consideration. It is a contract for the security and disposition of property. It is a contract on the faith of which real and personal estate has been conveyed to the corporation. It is then a contract within the letter of the Constitution and within its spirit also." Close quote. Chief Justice Marshaall laid out the constitutional protections and limitations that corporations would come to rely on for the rest of the 19th century and well into the 20th. Beyond the legal doctrine established, the case was also famous for its theatrics. Plaintiff's counsel in a case was none other than the greatest lawyer of the age, Daniel Webster. At the end of a nearly 4-hour argument before the court, he famously closed, his voice quivering, his eyes filled with tears, quoting, "Sir, you may destroy this little institution. It is weak. It is in your hands. It is, sir, as I have said, a small college, and yet there are those that love it." Close quote. As previously mentioned, from the appointment of Justice Story in 1812, the appointment of Smith Thompson in 1823, there was no turnover of justices. This represents the longest period of Supreme Court stability in its history, not by a little, but by a lot. But while the justices worked together in remarkable harmony, the political landscape of the young republic was going through seismic changes. The Federalists had been so weakened by this point, they did not run a candidate for the presidential election of 1820. The last time in our history where the incumbent ran unopposed. There are many reasons the Federalist star, once so bright, flickered and died. The infamous Alien and Sedition Acts passed during the Adams administration. The Federalist sympathy, support, and even collaboration with the English during the War of 1812, the Hartford Convention, the death of Washington and Hamilton, the defection to the Republicans of Madison, Monroe, and John Quincy Adams, the Jeffersonian Revolution of 1800, just to name a few. The demise of the Federalists would greatly impact the composition of the Supreme Court and make Marshall's last dozen years or so far less harmonious than the salad days of the 18 teens and 20s. Nominations to the court by Monroe, John Quincy Adams, and especially Andrew Jackson made Marshall's life increasingly difficult. During his 2 terms as Chief Justice, Andrew Jackson made 6 appointments to the United States Supreme Court, more than any other in the 19th century. Ranging from the famous to the virtually unknown, This group consisted of three late Marshaall Court appointees: John McLean of Ohio in 1829, Henry Baldwin of Pennsylvania in 1830, and James Wayne of Georgia in 1835, and three appointments at the outset of the Taney era: Roger Taney of Maryland, Philip Bauer of Virginia in 1836, and John Carleton of Tennessee in 1837. Together, these six justices transformed the Supreme Court. The last years of Marshall's tenure on the court were rather sad. Andrew Jackson had been elected president, a man he liked even less than Jefferson, who himself died in 1826. In 1831, Marshaall underwent bladder surgery without the benefit of anesthesia. When he was convalescing back in Richmond, his wife died. And when he finally did return to court, he was clearly a diminished man. But he did have one more fight in him, and that involved the Cherokee people of Georgia. I briefly mention the so-called Marshaall Trilogy: Johnson versus McIntosh, 1823, Cherokee Nation versus Georgia, 1831, and Worcester versus Georgia, 1832. These pivotal cases would be recognized the inherent tribal sovereignty right as the foundation of federal Indian law. The Marshaall Trilogy of cases brought us the working rules of federal, state, and tribal government interaction, close quote. I covered in depth these foundational cases of federal Indian law in my interviews with Professor Fletcher. So for a detailed description, consult episode 17 of my podcast, Federal Indian Law, Part 2. Marshall's death came on July 6, 1835, in the city of Philadelphia, just a few months shy of his 80th birthday. An extensive tribute was staged in Philadelphia and in many other cities across the country. Even those who did not care for his politics recognized the enormous contribution he made in constitutional development of the early republic. John Marshall's principal opinions were summarized by one of his biographers in the following manner, quoting, "In Marbury versus Madison, he established the foundational principle that a permanent written constitution controls a temporary Congress. In McCulloch versus Maryland, he made the government of the American people a living thing. In Gibbons versus Ogden, he wielded that people into a unit by force of their commercial interests." Close quote. Lastly, it cannot be forgotten what John Marshall did for the authority and prestige of the United States Supreme Court. John Jay, the first Chief Justice, resigned from the court to become governor of New York in 1795. President Adams wanted to reappoint him in 1800, but Jay declined. Writing the president, he said that he had left the bench perfectly convinced that under a system so defective, it would not obtain the energy, weight, and dignity which were essential. No such statement could be made at the end of Marshall's long tenure. The historian Charles Warren said, quoting, "In the 30 years he had transformed the Supreme Court from a weak and uncertain body, hesitating to measure its strength against the prevailing jealousy of the federal power, into an acknowledged supreme authority." Close quote. But by the time of his passing, Marshall had become deeply pessimistic about the future prospects of the Union. He wrote the year he died, quote, "I yield to the conviction that our Constitution cannot last. The Union has been preserved thus far by miracles. They cannot continue." Close quote. Little could he know that his own death would be a prime mover in the fulfillment of that prophecy, with the appointment of Chief Justice Roger Brooke Taney, the future author of the 1857 case, Dred Scott.